All right, good morning, everyone. Hope you all are doing well this morning.
Good morning, Your Honor.
Good morning.
We're going to start with the South Annex whenever you are ready, sir.
Okay, let's go ahead and bring the first person up. Thank you.
We're going to have Ms. Brianna White, position 39.
Hey, Anna, how are you doing there?
Good morning.
Judge, that's my case. If you can give me 3 minutes, I'm logging on my video now.
Okay. Morning. Are we ready to proceed, Ms. Helen?
Good morning, Judge. I am.
Good morning. Good morning, Ms. White. This is the state all-purpose calendar. I'm Judge Eric Morrow. We're conducting this calendar today by video. Do you agree to have your case heard by video?
I do agree.
Okay, thank you. Can you raise your right hand for me? Swear affirm the testimony I'm about to give before this court be the truth, the whole truth, and nothing but the truth.
I do agree.
You can put your hand down. Thank you, Ms. White. Ms. Helen, this is a non-negotiated plea.
That's correct, Judge.
Okay, let's see. May I get the history, Ms. Harrison? Good morning.
Let's see, 19 cycles with history in Minnesota, Tennessee, and Georgia. Last arrest was October of this year, possession and use of drug-related objects in Atlanta. No disposition listed in that arrest. Record does indicate an open probation for theft by taking, 18 SC 159711, sentenced June of 2019. 3 years confinement and 5 years probation. Additional open probation for entering auto. Willful obstruction of law enforcement officer by force by use of threats or violence, 21 SC 179808. Sentenced December 2021, 5 years probation. Additional open probation it's an open case in Clarkville, Georgia. No disposition listed. It appears to be an open case. 1 failure to appear and 1 violation of probation within the past 10 years. Nothing further to that.
Does it say what that open case is? What the charge is?
It's aggravated assault.
Okay, thank you. Good morning, Ms. Satole.
Good morning, Judge. The state's offer in this case is for count 1, simple assault, 12 months to serve, 60 days, balance probated, credit for time served, 17 days. No further contact with the victim, Lucky Patrick. Stay away from the incident location, 3665 MLK Junior Drive, Atlanta, Georgia, and completion of an 8-week anger awareness course. For count 2, simple battery against a police officer, 12 months to serve, 60 days, balance probated, credit for time served, 17 days. No further contact with the victim, Officer Khatib, and that's KHAT as in Tom, I-B as in boy, and an 8-week anger awareness course. And Judge, in this case, on October 15th of this year, at approximately 3:00 p.m., Officer Khatib responded to the incident location for a dispute call. Upon his arrival, he spoke with victim 1, who is the security guard for the grocery store, who stated that the defendant who is known to repeatedly harass customers at the store, refused to leave. When victim 1 asked her to leave, the defendant threw a plastic soda bottle toward him, but he missed. The defendant then picked up a large wooden stick and swung towards victim 1, but missed again. At that point, he was finally able to detain the defendant until the officer arrived. The defendant was arrested for simple assault and transported to Fulton County Jail. Once they arrived to Fulton County Jail, inside the Sally Port, the defendant attacked victim number 2, who is Officer Khatib, by kicking him in the stomach and spitting at him. And after running through her ACIC, the defendant had an active warrant out of Clarksville, Georgia, for aggravated assault. And Judge, this defendant does run the risk of reoffending. She is a danger to the community, and she also serves as a flight risk. She's a multi-state offender. She has history out of Tennessee and Minnesota. She has several convictions for violent offenses in her criminal history, and she also had a warrant for her arrest when she committed this offense.
Ms. Helen?
Yes, Judge, this is a non-negotiated plea. I do hear Mrs. White's history. I do believe those are 2 probation cases. So I don't believe she's a flight risk because she has probation here in the state and she wants to be able to report and get back to that probation, Judge. So I don't think she's a flight risk. I do hear the allegations, Judge. This is a non-negotiated because she believes she's done something wrong, Judge. We're just asking for it to be time served. The 17 days that she's done to be time served. With the state's recommendation, that'll be 13 additional days. We are asking that the 17 days that she has done be time served for this case, Judge. And she also agrees to the year of probation, as well as the anger management classes, Judge. I don't believe she's a danger to the community. I don't believe she's a danger to this officer or the security guard at the grocery store, Judge. So we are asking for time served in this case for Ms. White.
Not going to be a time served, Ms. Helen, given the history. If there wasn't a history, it would be time served, but I'm going to go with the state's recommendation. If Ms. White wants to accept that, we can move forward.
Ms. White, well, she's muted. Ms. White, do you want to talk to me on the phone or?
We can talk here. Nice to meet everybody. I've never been to Minnesota a day in my life.
Oh, wait. No, Ms. White, get on the phone with me so we can talk, okay? Judge, can I have an opportunity to call her real quick and we can go to another position?
Yes, of course you can.
We can go to the annex,
Jail court.
we can go to Ms. Moore. Ms. Moore from the state.
Ms.
I'm
Moore is
telling
my
you, Ms.
position
Helen.
too. She's my position too. I have all the
Okay.
females today.
What about Manassas, position 25?
Yep, I have all the females.
Okay. All right, just have a seat over there, please.
Heather, what's your positions again? 1 through 20 or 21?
I have 1 through 20.
Okay, so we're gonna start off position number 2, Mr. David Bonney.
That would be good.
Is this going to be a negotiated plea? Mr. Payne?
It is.
Okay, thank you. Good morning, Mr. Bonney. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Good morning, Ms. Ori.
Good morning, Your Honor. The state's offer in this case is 12 months to serve 30 days, credit for time served 15 days, the balance probated, a 12-week anger management course, no contact with the victim, whose name is Sunjin, that's SUNJIN, last name Lee, and to update his ID. Nothing further, Judge.
Mr. McLean?
Your Honor, that is a negotiated plea, and we asked the court to take it as part of the proceedings, if it would be possible, if there's a piece of paper at that courtroom for a use after court, for the deputy to text to me his address, his best mailing address. And that's sort of part of the, getting the ID.
Okay.
Thank you.
This is position number 2, Mr. Bonney. Okay, if we can unmute courtroom two, please. Mr. Bonnie, it's my understanding that in case 22 CR 007048E, you wish to plead guilty to simple battery, is that correct?
Yeah.
You under the influence of any drugs or alcohol this morning?
No, sir.
You can represent it by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Bonnie. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And Ms. Sorry, is there any objection to the probation terminating once he completes the terms?
Just 1 second, Judge. No, Your Honor.
Okay, and as soon as you get the 12 weeks of anger management done, Mr. Bonnie, the probation is going to terminate, okay?
Yes, Mr. Sir.
All right, good luck to you, Mr. Bonnie.
You go sit down.
Thank you, Your Honor.
Next, we have position number 13, Mr. Jamel Frazier.
And that is, of course, the negotiated plea as well.
Thank you. Good morning, Mr. Frazier. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Frazier? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Ms. Sorry.
Yes, Your Honor. The offer in this case is 12 months to serve 30 days, credit for time served 15 days, the balance probated.
Excuse me, Ms. Sorry. I'm so sorry. Mr. Huffstetler, please get dressed or turn your video off. I apologize, Ms. Sorry.
No problem, Your Honor. The state's offer is 12 months to serve 30 days, credit for time served 15 days, the balance probated, an 8-week anger management course, no contact with the victims, whose names are Daryl Mitchell, Shannon Puryear, and Enrico Jackson, and to stay away from the Jefferson Place Transition House at 1135 Jefferson Street in Atlanta. Nothing further.
Ms. McLean?
We just asked the court to accept the negotiated plea, Your Honor. His best mailing address will be the shelter, I believe, Crossroads. Not technically a shelter, but a contact point for people who are residentially challenged.
Okay. Mr. Frazier, it's my understanding that in case 22 CR 007023E, that you wish to plead guilty to 3 counts of simple battery and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Not at all.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this, on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. Frazier. I'm going to waive the probation fees for you while you're on probation. Is there any objection to it going to a non-reporting status? I'm sorry.
No, Your Honor.
Okay, and when you complete the terms, Mr. Frazier, it'll go to a non-reporting status, which means that the sooner you get these things done, the sooner you won't have to report to probation, okay?
Yes, sir.
All right, good luck to you, Mr. Frazier.
Next, we have position number 3, Mr. Tyrone Boykin.
This is Raymond on a bond hearing.
Yes, Your Honor, it is.
May I get his bond? Good morning, Mr. Boykin. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. I'm Judge Eric Morrow. This is a state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Mr. Boykin, you've been charged in case 22 CR 006832E with battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We did.
How do you plead, Mr. Boykin? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you will get notification of your next hearing date. Mr. McLean, on October 11th, I issued a $4,000 good bond to Mr. Boykin. Have any circumstances changed regarding that?
Your Honor, he is, the only circumstances changed is just his efforts, his efforts have failed to make that $4,000 bond. I'm not sure that's the actual change circumstance. I can tell Your Honor some factors about him that speak well for perhaps cutting the bond in half.
Okay, go ahead.
Your Honor, he is a stable member of the community, grew up in Carrollton, Georgia, graduated Carrollton High School. He has 2 children, 21 and 14. The 14-year-old he supports, and who is a student at Temple Middle School in Temple, Georgia. He works hard. The defendant works hard. The job that he obtained prior to going into custody is waiting on him at Honda Lock. They make car parts. And prior to that, he worked at Pilgrim's Pride and Buckhead Beef. So he's asking if the bond could be $2,000 instead of $4,000. He has talked to enough relatives where he thinks he can make that.
Okay, given that the state is asking for 180 days, I take it that he's got some violence in his history. Is that right, Ms. Sari?
Yes, Your Honor, that's correct.
And what would that be?
Your Honor, he has a 2016 simple battery family violence guilty conviction. That was against a different victim. He also violated probation that year. He has a 2019 battery family violence guilty conviction. That was a second victim. And then he has a 2020 probation violation. So that's essentially 3 different women, 3 different victims of violence. As we've heard from the defense, there's no change in circumstances. Your Honor, briefly, the facts are that the victim, Kishana Tucker, she and the defendant were sitting in a car at an intersection, and that's when he was upset from an argument earlier. He started punching her multiple times in the face, and she felt so intimidated and fearful that she actually jumped out of the car as they were at the intersection. So, Your Honor, this is a violent offender. He's a danger to this community. He has 3 victims, and we just ask that the bond remain as set, nothing further.
Mr. McLean, I think that my bond was reasonable when I said it. I think it's reasonable today, and it will remain the same. Good luck to you, Mr. Boykin. Who do we have next?
Position 31.
And this is also going to be an arraignment and a bond hearing. Let's see.
Which position, Judge? I was speaking to Ms. White.
This is position 31.
That's correct. And we're ready on Ms. White, Judge, whenever you're ready.
Okay, so let's go ahead and take Mr. Mott first, since he's already here. Good morning, Mr. Mott. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, all right, you can put your hand down, Mr. Mott. Okay, you've been charged in case 22 CR 006853F with simple battery and reckless conduct. Each of these charges carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Helen?
I do, Judge.
Mr. Mott, how do you plead to these charges? Guilty or not guilty?
Not guilty, Your Honor.
Okay, we'll record your not guilty plea, Mr. Mott. Your case will be returned to the division judge, and you'll get notification of your next hearing date. It appears that the bond for Mr. Mott is a total of $3,000 good bond, $1,500 on each charge. That was not issued by me. Ms. Helen?
Yes, Judge. Can I have pretrial read the history, please?
One moment, please. "16 cycles, last arrest December of 2021 for cruel to the children and terroristic threats in Fulton County. No disposition listed on that arrest. Record indicates an open probation in Fulton County. 22 SC 180611, sentence September of this year, 3 years probation and 2 years confinement. Record indicates an additional open probation for burglary, 15 SC 139694, sentenced October of 2016, 2 years confinement and 10 years probation. One moment. And let's see. Record indicates a terroristic threats and act in Fulton County. That was a confinement conviction. Aggravated assault, family violence under case 14 SC 124471. 3 violations of probation within the past 10 years. Nothing further to add.
Ms. Harrison, the
Yes.
first open probation, what were those charges?
It was terroristic threats.
Okay, thank you. Ms. Helen?
Yes, Judge. This is a bond hearing today for Mr. Mott. He's 25 years old. He's a lifetime resident of Fulton County. He was born at Grady Hospital. He does have strong family ties here in Georgia. His mom, his dad. He does have a high school history from Carver High School here in Georgia. He was working prior to being incarcerated, Judge, so he is employable. Right now, I'm going to ask for a bond modification to no more, to a signature bond of the same amount, Judge. If you feel that he's ineligible for that signature bond, we're asking for a bond modification for the reckless conduct, no more than $1,000 surety. For the simple battery, $500 surety. Like I said, he also has 2 brothers, 2 sisters here in Fulton County. Judge, we're asking for that signature bond. When I spoke to Mr. Mott, he's not able to afford the $3,000 surety as it stands. So we're asking for that signature bond modification. The Ayala factors, I do believe he's going to come to all of his court dates. He's not going to miss any court dates, Judge. He has no contact with the alleged accuser, Judge, and I do hear his history, but when I spoke to Mr. Mott, he understands how serious this case is, as well as his probation cases, Judge, and so we are asking for that bond modification.
Ms. Helen, based on the history, I don't feel comfortable with reducing the bond at this time that was issued by someone besides me. As such, the bond's going to remain the same. Good luck to you, Mr. Mott. Who do we have next?
Next, we have Ms. Moore, position 29 and 28.
Can we do Ms. White before we do Ms. Moore?
Oh, I'm sorry. Ms. White is sitting right there.
All right, Ms. Helen, you've had an opportunity to speak with Ms. White. What are we going to do today?
Yes, Judge. She wanted the court to know, as well as you to know, Judge, a few things. Number one, she's a part of the PAD program in jail. She was referred to that program in jail. She works with Step Up, which is a job training aspect of that. She works with vocational skills in that program. She works with life skills, Judge. She wants to give a little bit more clarification about that Habersham County charge. That was a jail incident that happened inside of the jail, which she is working with with her family to try to remove that warrant and figure out what that is, Judge. So she just wanted to clear up that history. This is not a long-standing violent offender, and she wants this court to know that, Judge. We are asking for the time served, Judge, for the 17 days that she's done to be time served with the probated conditions.
Okay, anything further, Mr. Tole?
No, Judge, the state would object to that and request for you to keep your same ruling.
And I don't mean to interrupt, but Ms. White also said that she had never been to Minnesota or Tennessee, has no idea about those allegations that are going on in that state with her name, Judge. She's only aware of this case here and these probation cases here in Georgia, Judge.
All right, I'll do one or two things, Ms. Helen. Either I can put this on next week's SAP calendar for you to do some research into those other charges. And at that point in time, she will have been in custody for, I believe, 24 days. And I would, if it comes back that that's accurate, then I will be willing to consider time served at 24 days. If it comes back inaccurate, then I'm going to proceed with the sentence that is recommended by the state. What would you like to do?
I'd like to reset it for next week. I'm gonna do some investigation into those Tennessee allegations and Minnesota allegations and bring Ms. White back for another opportunity in front of this court.
All right, so that's going to be 11/8. We'll see you back next week, Ms. White.
Thank you, Judge.
Position 29 and 30, Ms. Moore.
These are both negotiated pleas.
That is correct, Judge.
Good morning, Ms. Moore. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you, Ms. Moore. Mr. Tole?
Judge, position 29, the state's recommendation is credit for time served 18 days, balance suspended, stay away from the incident location, 2595 MLK Junior Drive, Southwest Atlanta, Georgia, 30311. And for position 30, the state's bond recommendation is credit for time served 18 days, balance suspended, stay away from the incident location, 2636 MLK Junior Drive, Southwest Atlanta, Georgia, 30311.
And Judge, that is our understanding of both of those pleas. We stipulate to both positions to the factual basis, venue, and ID, Judge.
All right, Ms. Moore, it's my understanding that in case 22 CR 005375D, you wish to plead guilty to criminal trespass, and in case 22 CR 006974D, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation? Are you happy with, are you happy with Ms. Helen's, what she's done for you?
Yes, sir.
You understand you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I don't understand because I've never been locked up before.
Okay, you don't want a jury trial, do you, Ms. Moore?
No, sir.
Okay, has anybody forced you or coerced you to plead guilty?
No, sir.
I'll accept the guilty pleas as negotiated, Ms. Moore. Good luck to you, ma'am.
Thank
Yes.
you, Judge.
Come on, Ms. Manakis. Position 25.
Also a negotiated plea.
That is correct, Judge.
Good morning, Ms. Manakis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. Mr. Tole?
Yes, Judge, the state's bond recommendation for count 1 simple battery is 12 months to serve, 39 days, credit for time served, 19 days, balance probated, no further contact with Officer Mayfield's, and an 8-week anger awareness course. And for count 2, simple assault is 12 months to serve, 39 days. Credit for time served, 19 days, balance probated, no further contact with Officer Mayfield, and an 8-week anger awareness. And that's to run concurrent. And does the defense stipulate to the factual basis, venue, and ID?
Mr. Tole, do you intend for this to be a time served plea?
Yes, Judge. That's
Should not be 38 days instead of
I
39?
should be in there for 19 days. Let me see.
I have 19 days.
38 days. That's
Yep.
correct, Judge. Yep, that's correct.
Okay, so 38 days. All right, thank you. Ms. Helen?
That is correct, Judge. This is a time served deal. We do stipulate to the factual basis, venue, and ID. We ask this court to accept the plea as negotiated. It's balance probated. We are asking for those probation fees to be waived. And if the state is amenable, can it be non-reporting once Jasmine completes all the conditions?
Any objection to non-reporting?
Let's see, her history. Yes, Judge, objection to that due to her criminal history.
Okay. I'm going to waive the fees, Ms. Helen, for the entire time that she's on probation, but she'll have to be on probation for the 12 months, okay?
Understood, Judge.
All right. Ms. Menakis, it's my understanding that in case 22 CR 006961F, you wish to plead guilty to simple battery and simple assault. Is that correct? You're on mute, South Annex.
Yes, sir.
Okay. Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
I will accept the guilty pleas as negotiated. I am going to waive the fees for you, the probation fees for you while you're on probation to help you get and stay on your feet. But you'll have to be on probation for the entire time, okay?
Yes, sir.
All right, good luck to you, ma'am.
Thank you.
Thank you, Judge.
Next, we have position 16, Ms. Greer.
It's Milton, how many more you got?
This is my last one. I appreciate your help.
And Judge, this is a negotiated plea. Just wanted to make an update from the announcement.
Okay, so, and this is position 16, Ms. Greer,
That's correct, Judge.
and she is not represented by a private attorney, but by you, Ms. Helen.
That is correct, Judge.
Can you tell me again what's this is going to be?
A negotiated plea, Your Honor.
Very good, thank you. Good morning, Ms. Greer. I'm Judge Eric. Good morning. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand? Do you swear affirm testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. Ms. Sorry.
Yes, Your Honor, the state's offer in this case is 12 months to serve 120 days, credit for time served, 60 days, balance would be probated. No contact with the victim, whose name is Quintilla, that's Quintella. Last name is Holloway, and stay away from 2374 Meadow Park Drive in Atlanta. And I'm gonna just go ahead and do balance suspended instead of probation. Nothing further.
Okay, Ms. Helen.
Yes, Judge, that's our understanding of the plea. I asked the court to accept that plea as negotiated. We do stipulate to the factual basis, venue, and ID.
Ms. Greer, it's my understanding that in case 20C0V000360G, that you wish to plead guilty to simple assault and simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, no, sir.
You've been represented by counsel. Are you satisfied with her representation?
Sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Greer. Good luck to you, ma'am.
Thank you, sir.
You're welcome.
Thank you, Your Honor. May we be excused, please?
Yes, have a good rest of the day.
Yes, sir.
Thank you, Judge. Thank you, Officer Milton.
You're welcome.
All right, where are we going next?
Position 15, Gilmore.
And this is going to be an arraignment and a bond hearing, is that correct?
Yes, Your Honor. Your Honor, would it be possible for us to jump to another one? I'm expecting a text in just a second from social worker confirming something about Mr. Gilmore's situation. He interviewed him yesterday as well as my interview.
Hey, Judge, I'm ready for positions 21 through 40.
Okay, Mr. McLean is requesting that we come back to Mr. Gilmore as he's waiting for some information regarding him. So can we go to someone else, please?
Also, if I might interject, Your Honor, I had announced on the announcements to be announced TBA on Mr. Burke, and now I've received the information that that is ready for a negotiated plea.
Okay,
Mr. Knox. Position 22, Knox.
this is going to be an arraignment and a bond hearing.
That's correct, Judge.
Good morning, Mr. Knox. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Knox. You've been charged in case 22 CR 007029F with theft by taking 2 counts. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. McLean?
I do, Judge.
How do you plead to these charges, Mr. Knox? Guilty or not guilty? We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Let's see. I issued a $1,000 good bond on both charges on October 18th, making for a total of a $2,000 good bond in this matter. Ms. Harrison, may I get the history, please?
18 cycles, last arrest, January of 2021 for probation violation in Coweta County, Georgia. No disposition listed on that arrest. Record does indicate an open probation, forgery in the 3rd degree, 17 SC 155084, sentenced October of 2017, 5 years probation. Probation violation 2021, 2020, 2002 and 2020, 2019. An arrest only for battery, family violence, aggravated assault, and a burglary. No disposition listed. Appears to be an arrest.
Okay,
And nothing further, Judge.
thank you, Ms. Harrison. Mr. Tolley, what were the facts of these allegations?
Yes, Judge. So for the first theft by taking charge on September the 9th of this year, the defendant stole 2 catalytic converters from 2 vehicles on the property of the business owner. The incident was caught on video and the defendant was seen at the business earlier in the day. The business owner has known the defendant for 10 years and positively identified him from one photo. For the second theft by taking charge on September 12th of this year, the defendant did the same thing that he did on September 9th. And the only difference is he stole one catalytic converter this time instead of two. And this was also caught on camera. And Judge, we would request for the bond to remain the same of $1,000 for each count due to him currently being held for violating probation for felony charges of forgery in the 3rd degree, 2 counts of theft by taken, financial identity fraud. And in that case, he was given 5 years probation. And he reoffended while he was on probation for the charges that I just mentioned. He also has 5 probation violations in his history and 1 theft by taking conviction, which does show his ability to reoffend. So as a result, the state would request for the bond to remain as set.
Thank you, Ms. Helen.
Yes, Judge. Today, this is a bond hearing. Mr. Knox is 45 years old. He's a lifetime resident of Fulton County. He was born at Grady Hospital. Currently, he has 10 kids that he is a primary caregiver of from the ages of late 28 to 8 years old, Your Honor. He is an automotive technician, so he is employable. He's done that for the last 3 years, Judge. He does have strong family ties here in Georgia. Mom is in Fulton County. Dad is in Coweta County. He participates in a mentoringship program that's called One More Question. He started that program before he got arrested, Judge. I do hear the probation violations. I do hear the history, but I still hear that those cases are still open. I believe he understands how serious his probations are, and he understands the seriousness of this case, Judge. He's not able to make that $2,000 surety. We're asking for a $2,000 signature bond. I do not believe he's a danger to the community. I've spoken to Mr. Knox. We've gone over his history. I do not believe he's a danger to reoffending. He understands how serious these cases are, Judge. So we are asking for that signature bond modification. And if not, we're asking for a total $1,000 surety bond modification, $500 each on the theft by takings.
Based on its history, I believe that the bond that I issued on October 18th is reasonable. I continue to think that it's reasonable. I'm going to have it remain the same. Good luck to you, Mr. Knox. Who do we have next?
Position 45, Sal Mr. Williams.
Forty.
Negotiated plea, is that correct?
That's correct, Judge.
Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, Mr. Williams. Mr. Tole?
Yes, Judge, the state's bond recommendation is credit for time served 120 days and stay away from the Walgreens on 25 Peachtree Street, Southwest Atlanta, Georgia, 30303. And so it's the same thing for both charges, Judge. And does the defense stipulate to the factual basis, venue, and ID?
So this is 120 days. He's served 120 days. His balance going to be suspended.
Yes, that's correct, Judge. Mm-hmm.
Is that your understanding, Ms. Helen?
Yes, Judge, that is our understanding of the plea. We do stipulate to the factual basis, venue, and ID.
All right. Mr. Williams, it's my understanding that in case 22 CR 007330J, you wish to plead guilty to possession of marijuana less than an ounce and obstruction of a law enforcement officer. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Was anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Williams. Good luck to you, sir.
Thank you.
You're welcome.
Good morning, Judge. How are you?
Good morning, sir. Okay. Where are we going next?
Position 10.
I'm sorry, I didn't get the position.
10.
10? Okay, thank you. What are we doing with this, Mr. McLean?
Your Honor, He tried to get through a plea before. He's going to try again today. He says he'd like to. I believe that there are mental health issues that rise to the level of competency and would prefer that we just put this on a Thursday competency hearing.
Okay, we're gonna transfer this to a competency calendar. What's the next? Say it again. Ms. McLean, have you requested a mental health evaluation?
No, Your Honor, but this afternoon I do have access to the form and can get that
Okay,
done.
all right, so he's gonna do that. What calendar can we place this on? All right, this is gonna go on the November 17th competency calendar.
Thank you, Your Honor. Would have tried to get, well, the hopes of yesterday were dashed, so I'll just leave it at that.
Okay, thank you. All right,
Yes.
so we're gonna reschedule Mr. Davis, okay? All right, who do we have next?
Position 38, Walker.
Arraignment and a bond hearing, is that right? Who's representing Mr. Walker?
I am, Judge. I just wanted to double check the bond on the criminal trespass and damage to see if that bond is holding him.
Well, from what I see, he's on hold for reckless conduct and battery family violence.
So there's no bond currently for the criminal trespass and damage to property, then it'll be an arraignment, Your Honor, if there's no bond holding him for this one.
Oh.
Because I believe he already made it. I just wanted to make sure that that's what's being reflected.
That's your understanding, Mr. Tole?
That is my understanding, and we can double check with pretrial if
He has an additional open case, 21 CP 199513, felony theft by taking and simple assault.
Okay, so this is just gonna be an arraignment, is that correct, Ms. Helen?
That's correct, Judge.
Good morning, Mr. Walker. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. I'm being told, Ms. Helen, that Mr. Walker's already been arraigned, so that won't be necessary this morning.
I do have one question. Is it possible that probation is able to put him on their calendar for his other probation case that's holding him? Is that possible?
You want to put on for what, next week or something?
Yes, Your
Sure,
Honor,
yes,
because I believe he has a misdemeanor probation hold and he sat there for about 3 months or more. And
All right, well, I'm happy to put him on next week's calendar. You can check with probation.
Yes.
to see if we can get him on that calendar, and I'll hear all this together next week. Is that what you would like?
yes, Your Honor.
Okay, so that's gonna be 11/8, and you'll have to follow up to make sure, Ms. Helen, okay?
Yes, Your Honor. I'll send an email now. Thank you.
Okay, Mr. Walker, I'll see you next week, okay?
Thank you, Mr. Walker.
You have a court notice? Let's see, witness. Okay.
Position 36, Stevens.
Okay. Negotiated plea.
That's correct, Judge.
That's correct, Judge. I was muted.
And let's see. I don't, my calendar does not reflect the names. Can someone tell me the name?
Oh, Renardo Stevens?
Yes, Mr. Stevens, I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Mr. Tole?
Yes, Judge, for count one, conspiracy to commit a misdemeanor, the state's recommendation is a credit for time served, 117 days, balance suspended, stay away from the incident location, 1430 Lakewood Avenue, Southeast Atlanta, Georgia. And for count two, possession and use of drug-related objects, credit for time served, 117 days, balance suspended, stay away from the incident location, 1430 Lakewood Avenue, Southeast Atlanta. And that's to run concurrent. And does the defense stipulate to the factual basis, venue, and ID?
I do, Judge. Stipulate to the factual basis, venue, and ID, and I ask this court to accept the plea as negotiated.
Okay, Mr. Stevens, it's my understanding that in case 22 CR 007324J, you wish to plead guilty to conspiracy to commit a misdemeanor and possession and use of drug-related objects. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the pleas as negotiated, Mr. Stevens. Good luck to you, sir. Where to next?
Position 32 Postal.
This is a non-negotiated plea.
Yes, Judge, the only thing that's at issue is if this court will allow him to use his NOLO plea. And that's what I'm petitioning and asking this court to allow him to do.
No objection to that, Judge.
Okay, so it's negotiated.
That is correct. And
All right.
Mr. Postel, you'll be entering your NOLO plea.
Ms. Postel, I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Mr. Tole?
Yes, Judge, the state's bond recommendation is for count one, reckless conduct, credit for time served, 131 days. Count two, DUI, driving under the influence, 12 months to serve, 262 days, credit for time served, 131 days, balance probated, a risk reduction course, random screenings, and alcohol drug evaluation treatment, 20 hours of community service, and a $500 fine.
I
For count-
apologize, don't want to interrupt you. I have that the reckless driving has been dismissed. So I just want to make sure I have the paperwork correct.
Let me double check for that. I don't have that reflected, but
Is the reckless conduct something different than the DUI charge?
On Odyssey, I wanted to make sure that I followed. Okay, that was actually misstatement. Go ahead and continue. Those were three other charges that were dismissed.
Reckless driving.
yeah, it's, okay, so I have 9 counts, reckless driving, DUI under the influence, driving with a license suspended, but none of the charges are dismissed from my end and just hadn't dismissed anything.
There's no reckless conduct, there's reckless driving. You got
Yes,
reckless
correct.
conduct in the recommendation, so is that supposed to be reckless driving?
Understood. I just saw on Odyssey that some others were dismissed, but that's just my misunderstanding. She can continue.
Yes. Okay. The fleeing and attempting to elude, that was transferred to the DA's office. However, they decided to dismiss that one and they dismissed the failure to yield right of way. But I'll continue. For count 3, driving while license suspended or revoked, credit for time served, 131 days, and no driving without a valid license. For count 4, passing within 200 feet of oncoming traffic, credit for time served, 131 days. Count 5, possession of open alcohol container, credit for time served, 131 days. Count 6, failure to obey traffic signs, signals, and markings. That's credit for time served, 131 days. And count 7, failure to maintain lane or improper lane change is going to merge with count 6. Count 8, improper turn / improper lane change, merge with count 6. And lastly, count 9, use of safety belt in passenger vehicles. That's going to also merge with count 6.
And yes, Your Honor, that is our understanding of the plea. We do stipulate to the factual basis, venue, and ID. We ask this court to accept the plea as negotiated, but it is probated, so we're just asking for the probation fees to be waived, Judge.
Okay, anything further?
No, Judge.
Mr. Postel, it's my understanding that in case 22 CR 007326C, you wish to plead no low to reckless driving, driving under the influence, driving while your license was suspended or revoked, passing within 200 feet of oncoming traffic, possession of open alcohol container, and a failure to obey traffic signs, signals, and markings. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading no low to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead no low?
Yes, sir.
I will accept the no low plea as negotiated. I'm going to waive the probation fees while you're on probation, but you'll be required to remain on probation for the entire time. Good luck to you, sir.
Position number 28, McCrary on 5 South.
And then I spoke to Mr. McQuarrie, who said he had a private attorney, John or Mark, who would appear for him today.
Where is Mr. McQuarrie?
5 South.
Mr. McQuarrie, have you been in contact with an attorney regarding this matter?
Yes, sir.
What's your attorney's name?
John McCarthy.
John, what's the last name?
McCarthy.
Do we have any entries of appearance? 28. What?
Yes, sir.
Hold on. Okay, Mr. McCurry, we do not have an entry of appearance for that, for counsel for you. When's the last time you spoke with him?
I spoke to him yesterday.
Okay, have you already paid him?
Yes.
All right. We're gonna have to give, he does not appear to be here with us today. The state is asking for additional jail time in this matter. As such, I'm going to give him till next week, 11/8, to make entry of appearance on your behalf. And if you speak with him, you need to let him know that he needs to do that, okay?
Yes, sir.
All right, so I'll see you back next Tuesday. I don't know. McQuarrie? No. Who do we have next?
34, Reed.
Oh, by the way, Your Honor, the Gilbert information I now received.
Okay. And who's representing Mr. Reed?
I apologize, Judge. When I went down and spoke to Mr. Reed, he told me he had paid and retained a private attorney, but a Neil Heiseman. But he didn't have the number, Judge, but he did say that he had retained him.
All right. And Mr. Reed, when's the last time you spoke with your attorney?
Well, the 8th Amendment right is being violated. Mine, I'm just filing a lawsuit, man. They done robbed,
Okay, my question to you is, do you have an attorney representing you on this
Yes,
matter?
sir. Neil Henderson, Darren, Georgia location, man. Eighth Amendment right being violated, man. They don't route me, man.
Miss Helen? Miss Helen?
And assault.
Okay, hold on, Mr. Reed. Hold on, Mr. Reed. When you spoke to him, Miss Helen, did you notice any issues?
No, he seemed really animated, but he also seemed pretty certain that he paid and hired this attorney and was able to give me a first and last name. I can revisit Mr. Reed, maybe even have a social worker go visit him. But I'd like to get in contact with his counsel if he has retained them.
Okay. Mr. Reed, we don't have any indication that there's anyone representing you. I'm happy to let Ms. Helen represent you or try to get in touch with the counsel that you have said that is representing you, but we don't have a notice of appearance for anyone representing you, Mr. Reed. All right. I'm going to give you that opportunity, Ms. Helen. And I will reset this till next week's calendar.
Understood, Judge.
Okay, thank you. The court appreciates that. Okay, where to next?
4, 5, and 6.
Those are negotiated pleas.
Okay. Good morning, Mr. Brooks. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Case from video? Yes. Do you agree? Yes, yes.
Okay, can you raise your right hand for me, Mr. Brooks? Can you raise your, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, yes, sir. Yes, sir.
Okay, I'm not sure if it's Mr. Brooks or if we have a bad connection. Okay. All right, I'm being told that it's the jail. We're gonna need to get a good connection to get through these pleas.
Your Honor, he is being held on other charges. If next week would be better to solve these technological problems, that would not make a difference in custody.
Okay, let's see. Okay, can you hear me, Mr. Brooks?
Yes, sir. Yes, yes, sir. Yes, sir. Yes.
Okay, all right. So let's see if we can proceed with Mr. Brooks and see if we can get through this. Ms. Sorry. Hold on, I'm sorry. Mr. Brooks, did you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, sir.
Okay, thank you. Ms. Sorry.
Yes, Your Honor, for each position, that's 4, 5, and 6, the state's offer is 12 months to serve 365 days, credit for time served 365 days, no contact with Vanessa Owens, and to stay away from 2544 Connolly Drive in East Point. Nothing further.
Mr. McLean.
That is correct, Your Honor. That is a negotiated plea, and he wishes to ask the court to accept that.
All right.
It happened in 2019 in the fall.
Mr. Brooks, it's my understanding that you wish to plead guilty in case 20 CR 005456G to criminal trespass, in case 20 CR 005465G to criminal trespass, and in case 20 CR 005466G to 2 counts of criminal trespass. Is that correct?
Yes, yes, sir. Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir. No, sir.
You've been represented by counsel. Are you satisfied with his representations?
Yes, sir. Yes, sir.
You have a right to a trial by jury on these charges. And do you understand that you're giving up your right to a trial by jury by pleading guilty?
Yes, sir. Yes, sir.
Has anyone forced you to plead guilty?
No, sir, no, sir.
Thank you, Mr. Brooks. I'll accept the guilty pleas as negotiated. Good luck to you, sir.
And Your Honor, I'll sign for him.
I believe it was, yes. Well, it's 365. I don't think that there is a balance.
That's correct, Judge.
Okay, you have to say the, no first contact.
Right.
All right. Who do we have next?
Position 7, Burke.
Mr. Burke's negotiated plea. I received word through texting that of what the plea is. And so another member of my office has negotiated that plea, but I will sign for him with his permission and authorization.
Okay. Good morning, Mr. Burke. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Burke. Ms. Sorry.
Yes, Your Honor. The state's offer in this case is 12 months to serve 288 days, credit for time served 144 days, and the balance suspended. Nothing further.
That is my understanding, Your Honor. The state, we're asking, is that every charge, or we got to do a separate sheet on each charge?
That is for each charge.
That was my understanding as well. Thank you.
Well,
Mr. Burke, it's my understanding that in case 22 CR 007325E, that you wish to plead guilty to reckless driving, failure to obey a stop sign, failure to signal a lane change, willful obstruction of a law enforcement officer, possession and use of drug-related objects, and possession of open alcohol container. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept a plea as negotiated. Good luck to you, Mr. Burke.
Thank you.
Position 33, Price.
Okay. And this is going to be a non-negotiated plea.
That's correct, Judge. We just want to be able to swap out the community server, the anger management with community service if the state and this court would be amenable.
And why is that?
He's not able to afford the 8 anger managements, but we wanted to be able to swap out something that's comparable in the community service amount so that he'd be able to do that.
And what is your suggestion as to what is comparable?
25 hours of community service.
Ms. Satole?
It's just because the location where this happened, because he's residentially challenged. He was,
I understand, Ms. Helen. I'm trying to get this to be negotiated. Ms. Satole, what's?
Yes, Judge, that's okay. Yes, the state will consent to that. That's fine.
All right, very good. Thank you. So it's a negotiated plea.
That is correct.
All right. Mr. Price, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Price. Thank you. Ms. Satole?
Yes, Judge, the state's bond recommendation is 12 months to serve, 32 days, credit for time served, 16 days, balance probated, no further contact with the victim, Aaron Carmen. It was completion of an 8-week anger awareness course. However, was it 25 hours?
25.
Okay, 25 hours of community service, and to stay away from the incident location 165 Ivan Allen Jr. Boulevard, Northwest, Atlanta, Georgia 30313. And does defense stipulate to the factual basis, venue, and ID?
I do. This is also, he has clothing here. He would like an opportunity to go with an officer one time to gather those things. I just wanted to petition the court, see if that was okay, but I do stipulate to the factual basis, venue, and ID.
Okay, yeah, that's fine. He can have a one-time escort with law enforcement to retrieve any belongings that he might have at that location. Mr. Tolley, any objection to non-reporting when he completes the community service?
No objection, Judge.
And I'm asking for the probation fees to be waived, Your Honor.
Okay. Mr. Price, it's my understanding that in case 22 CR 006978F, you wish to plead guilty to battery. Is that correct?
Sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Price. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. When you complete the 25 hours of community service, it will go to the probation will go to a non-reporting status, and you can go back to that incident location on one occasion with law enforcement to retrieve any belongings that you might have there, okay?
Yes, sir.
All right, good luck to you, Mr. Price.
Thank you, Judge.
You're welcome.
Position 27, Martin.
Negotiated plea.
That is correct, Judge.
Good morning, Mr. Martin. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay. Mr. Tolley?
Yes, Judge, the state's bond recommendation is 12 months to serve, 36 days, credit for time served, 18 days, balance probated, no further contact with the victim, Zaria Aki, and that's Zaria, last name A, C as in cat, K as in kite, EY, and an 8-week anger management course.
Yes, Judge. Oh, sorry.
Does the defense stipulate to the factual basis, venue, and ID?
I do. I do ask this court to accept this plea as negotiated. It is probated. We are asking for those probation fees to be waived. And Judge, if the state is amenable, if it can be non-reporting once he completes those conditions.
Any objection, Mr. Tolley?
Yes, we would object to that because due to the criminal history, he doesn't have a lengthy one. However, he does have an open case against the same victim. And then the victim also has an open case of battery family violence against the defendant. So as a result, we would like for it to remain reported.
Okay. Mr. Martin, it's my understanding that in case 22 CR 006962Y, that you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I am going to accept the plea as negotiated, Mr. Martin. I'm going to waive your probation fees while you're on probation to help you get and stay on your feet. And when you finish the 8 weeks of anger management course, the probation will go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Mr. Martin.
Thank you, Judge.
Position number 11, Dewberry on 4 South.
What's the announcement on Mr. Dewberry?
He says that he is not guilty, Your Honor, and wishes to be arraigned. We can waive the formal hearing, formal reading because.
All right. Good morning, Mr. Dewberry. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Who's ever on the iPhone, the court, can we mute the? Okay, thank you. I'm sorry, Mr. Dewberry. We're conducting this hearing by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Mr. Dewberry, you've been charged in case 21 CR 007242G with simple battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation? Mr. McBride?
We do. We have read it.
Okay. How do you plead, Mr. Dewberry? Guilty or not guilty? How do you plead, Mr. Guilty or not guilty? Not guilty. Okay, we'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date, sir. Good luck to you.
Thank you, Your Honor.
Okay. Okay.
This is Mr. Myers, add-on position 3.
What are we doing, Mr. Myers, this morning? Ms. McLeod, is this your case?
I apologize, Judge. Which position did we call?
This is add-on position 3. I believe it's Ms. McLeod's case, if I'm not mistaken.
Okay.
Are you with us, Ms. McLeod?
Good morning, Your Honor, I am.
Good morning, Ms. McLeod. What are we gonna do with Mr. Myers this morning?
Your Honor, I would ask the court to modify his bond. He has a good bond at the moment, Your Honor, and he's been unable to post it.
Okay, so he needs to be arraigned also, is that right?
Yes, Your Honor, he also needs to be arraigned.
Okay, let's do the arraignment first. Good morning, Mr. Myers. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You can put your hand down, Mr. Myers. You've been charged in case 22 CR 006891J with simple battery in a public transit vehicle or station and 2 counts of disorderly conduct. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. McLeod? You're on mute, Ms. McLeod.
Yes, Your Honor, I do.
How do you plead, Mr. Myers, guilty or not guilty? You're on mute, courtroom too. Oh, there you go. Guilty or not guilty?
Guilty.
Okay. It's my understanding that you're going to plead not guilty to these charges today, Mr. Myers. Is that not correct?
Right.
It's my understanding that, speaking with your counsel, that you're going to plead not guilty to these charges today. Was that your understanding?
Yes.
That was my understanding, Your Honor.
Yes, sir. If I can get out of here today, that's what I need to do. I need to plead not guilty if I can get out of here today.
Okay, well, there's no guarantee that whether you plead not guilty or not guilty that you're going to be getting out today, Mr. Myers. So if you need time to speak with Ms. McLeod on this matter, I'm happy to give it to you. But simply because I don't know the facts of the case, I don't know whether I'm going to modify your bond or not. I don't even know what the state is offering on this case at the present time. So that being said, Mr. Myers, I'm happy to give you some time to speak with Ms. McLeod. Mr. Tolle, do you have the offer on the matter?
Yes, Judge. I just received this case this morning. So it's 12 months to serve, 36 days credit for time served, 18 days balance probated, 6 weeks anger management course, and no further contact with the victim, and to stay away from the incident location.
Okay, and let me hear the history of the matter. Ms. Harrison.
Yes, Judge. 8 cycles, last arrest, March of 2014 for possession of marijuana less than an ounce. No disposition listed on that arrest. Record indicates a 2008 theft by taken felony. He was given first offenders. It was sealed 2017. A 2003 carrying concealed weapon misdemeanor conviction, and an arrest for aggravated assault that was dismissed. Nothing further to add.
And what are the facts of this case, Mr. Tole?
Let me pull it up, Judge. So Judge, on October 13th of this year, he intentionally made physical contact by hitting another MARTA patron abroad on the southbound train. Let me see what else. The victim, Michael Anderson, also stated that the defendant kicked his hand for no reason while he was sitting on the train at the Lenox station. The victim also stated that it was a spontaneous utterance, that he stated, "I didn't kick him. I kicked his phone out of his hands." Surveillance footage was reviewed and showed that Anderson was sitting across from Myers. They both had their phones in their hands. Basically, the defendant kicked the victim's phone out of his hand without any prior interaction. And then he walked away. Bear with me, Judge. I'm sorry, I just got this case. I didn't even know I was going to present it.
You're fine, Mr. Tole.
So that's pretty much it. And if anyone, Ms. Sari, if you want to chime in, you can.
Yes, I'll just chime in a little bit. I just saw this case as well, Your Honor. But per our office, this is being investigated as a hate crime. The victim in the case said that the defendant yelled some hateful things regarding the LGBTQ community. So we are looking into this as a possible hate crime. The victim does want to go forward with this case. So we ask that Your Honor consider those facts when you do make your ruling. Nothing further.
Okay, so Ms. McLeod.
Yes, Your Honor.
So you've heard the offer on the matter, and you've also, you've also heard that they may be seeking to increase this to a hate crime. So
I heard when he initially appeared, Your Honor, that allegation was made. My client's side of the case is completely different, Your Honor. But of course, I would like to discuss the state's offer with my client.
Okay.
I would definitely like to speak with him. But I do believe, Your Honor, given the fact that he doesn't have any recent criminal history, he certainly doesn't have any history concerning the LGBTQ community or any kind of hate crime. And of course, he denies that this is what happened. My client says that the gentleman in question made an inappropriate sexual advance to him and took a photograph of him without his permission. And that was the reason why he reacted the way he did.
Okay. So what do you want to do this morning, Ms. McLeod? Do you want to speak with him regarding this?
I would like to speak with him, Your Honor.
Okay, so if you can just, I guess, call courtroom 2, we'll go on to the next person and give you that opportunity so he knows what his options are.
Thank you.
I'm gonna hold on to this.
McLeod, you have the number, right? 404-612-2392.
2392, yes.
Okay.
Okay, thank you. Who do we have next?
12.
Was not able to be seen again because of Well, as per the jail about behavior.
Do you need to talk to him?
I would, the circumstances are such that I really need to speak to him in person rather than during court day.
Okay, well, the only issue with that, that I see, Mr. McLean, and it's up to you, is that he has a time served, offer today. And if he accepts that, then it would be, I don't know if anything else is holding him or not. I'm happy to do whatever you would like me to do. I can put him off till.
Why don't I have the courtroom call me? I'll duck out in the hallway, and if they could call my cell number, which I give out freely, they could call me on that, or I could call them.
Did you hear that? Mr. McLean wants to speak with his client.
Yes. I can get his number
Okay,
and we'll call him.
all right, go ahead.
Right, that's 770-891-4755.
4755.
Correct. And I'll duck out in the hallway.
Okay, thank you. All right, so who do we have next? Do we have any of Ms. Helen's cases that are still pending? Who do we have at 4 North? Ms. Helen, what cases do you still have left on the calendar?
I believe that's Mr. Manuel, position 26, Johnny, at 4 North.
Is that your client?
Yes, Your Honor.
Can we do it 4 North? Are you all ready?
Black, you're muted.
I don't know if they can hear us.
Can you hear me, 4 North? Okay,
This is position number 26.
all right. And this is gonna be a negotiated plea, is my understanding, is that right?
That's correct, Judge.
Good morning, Mr. Manuel. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video? Can you hear me, sir?
Yes, I'm sorry. It's a little low.
Okay, I'll try to speak up. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down. Thank you, sir. Mr. Tole?
Yes, Judge, the state's bond recommendation for count 1, failure to obey traffic signal or light, is credit for time served 118 days. For count 2, possession of marijuana less than an ounce, is credit for time served 118 days. For count 3, theft by taken, 12 months to serve, 236 days, credit for time served 118 days, balance probated, no further contact with the victim, Jalery Davis, and that's Jalery. Stay away from the incident location, 185 First Street, Southwest Atlanta, Georgia, 30314, apartment B, and completion of an anti-theft course. For count 4, theft by taken, 12 months to serve, 236 days, credit for time served, 118 days, balance probated, no further contact with the victim, Jalery Davis. And Judge, for For count 5, theft by taking is going to be the same exact recommendation, and that is for it to run concurrent. And does the defense stipulate to the factual basis and venue?
We do, and Your Honor, this is a probated sentence. We're asking for the probation fees to be waived. And if the state's amenable, if it can be non-reporting after he completes that anti-theft course.
Any objection to non-reporting?
No objection to that, Judge.
Mr. Manuel, it's my understanding that in case 22 CR 007328B, you wish to plead guilty to failure to obey traffic signal or light, possession of marijuana less than an ounce, and 3 counts of theft by taking. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I understand.
Has anyone forced you or coerced you to plead guilty?
I do.
Nobody has forced you to plead guilty, have
Oh,
they?
no. Sorry.
Okay. I will accept the plea as negotiated. I'm going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And then when you complete the terms, it'll go to a non-reporting status, okay?
Yes.
All right. Good luck to you, sir.
Thank you.
You're welcome.
Thank you, Judge.
Going back to position 15, Gilmore.
Was this, I think this is Mr. McLean's case. Is that not right?
That's correct, Judge.
Okay, and he's on the phone at the present time.
Okay, we can go back to position add-on 3, Myers.
Let's see, is Ms. McLean,
That was Ms. McLeod.
Ms. McLeod with us?
She should be.
Okay, I think she probably had to log off and log back on. So we'll give her a moment to do that.
And you said McLean is on the phone?
Yes, he's outside the courtroom on the phone with his client.
These are the only 2, Judge, that we have left.
Okay, so as soon as Ms. McLeod or Mr. McLean comes back, we'll handle these.
Okay, thank you, Judge.
Okay, no, thank you. So I guess we'll be in recess until someone returns.
Okay.
Are you ready, Your Honor, for an announcement?
Yes.
Thank you, Your Honor. We had a long enough and detailed enough conversation where I can state there's a factual basis for the plea and stipulate to that. We discussed the facts thoroughly. I had already, of course, seen the police report in preparation for interviewing him prior to today anyway. So there's going to be a negotiated plea.
Okay, and tell me again,
That's Mr. Edwards, number 12.
okay,
It's just one count of theft by taking misdemeanor.
and do you need to get the plea paperwork to Mr. Edwards?
I'll sign for him. I discussed with him the types of questions that are on the police statement.
All right, so this is position number 12. Is this, are you back with us, is this Mr. Edwards here?
Yes, sir.
Okay,
Yes, sir.
all right, can you raise your right hand for me, Mr. Edwards?
All right here.
Yes, please. Can you hear me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you, sir. Ms. Sorry.
Yes, Your Honor, the state's offer in this case is 12 months to serve 166 days, credit for time served 83 days, the balance probated, an anti-theft course, no further violent contact with Officer John Stark, and stay away from the Wells Fargo at 240 Peachtree Street in Atlanta. Nothing further.
Mr. McLean.
Your Honor, that is our understanding of the plea, and we ask the court to accept that. We stipulate to the factual basis. This has to do with an allegation of fraud regarding borrowing a phone and then cash apping $30 to somebody while in possession of a borrowed phone.
All right. Mr. Edwards, it's my understanding that in case 21 CR 004263F, you wish to plead guilty to theft by taking, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Edwards. I'm going to waive the probation fees for you while you're on probation. And when you complete the anti-theft course, the probation is going to terminate, okay?
All right.
All right. Good luck to you, Mr. Edwards.
Thank you, Your Honor.
What, sir, Your Honor,
Yes, sir.
when do I go home?
Well, if you don't have anything holding you, then as soon as you get processed out by the jail, you'll be released.
I mentioned to him, Your Honor, I can't check holds right this moment, but I will check as soon as court's over with.
Okay, Mr. McLean's going to make sure that you don't have anything holding you, and if you don't have anything holding you, then you'll be processed out. Okay.
All right, thank you, sir.
You're welcome. Have a good day.
Position number 1, Banks on 4 North.
Chaz Banks is number 1. That's a not guilty. Bond is moot at this time.
Okay, so it's just going to be an arraignment.
Correct. We've read the indictment. I mean, the accusation. I'm sorry. We've read it together, and so we waive the reading. Just need to arraign him.
Good morning, Mr. Banks. I'm Judge Eric Morrow. This is the state all-purpose calendar. Do you agree to have your case? We're doing this by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me?
Can you repeat that?
Are you able to raise your right hand for me?
Yes.
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Banks. You've been charged in case 20 CR 005640G with theft by taking. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding, Mr. McLean, that you're going to waive formal reading of the accusation.
Correct, Your Honor.
How do you plead, Mr. Banks? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, sir.
All right, thank you.
You're welcome.
Thank you, Your Honor. Your Honor, I do have a request. I've been looking over some things and texting. I have a request on case number 837 and an add-on under the name Carlos Daniels.
So position 8
And 37
and 37
and an add-on under the name Carlos Daniels.
Okay, 8, 37. And Carlos Daniels. And what's the request?
Your Honor, this is the same person. In 8 and 37, the hyphenated last name is just switched around. It's, Your Honor, can see Chavez Vasquez or Vasquez Chavez. Also, the name is Carlos Daniels. I need additional time. I came upon the Daniels case yesterday, and I had requested a week, I believe it was, to get a program for him. His mother has found a program, and I need to investigate the third case and talk to the state about whether there's an offer in the first case. It's kind of complicated, but I would like one more week to do
Okay,
that.
you're fine. So we're going to reset this till next week, all 3 of these cases until November 8th.
Very good.
Okay.
I should be prepared at that time with details about the program.
All right, very good. So position 8, 37, and add-on 1 will be reset until next Tuesday.
Right, and there's one element where I will find out if the state intends to go forward on one or transfer to the DA.
Okay, fine. Thank you. Has Ms. McLeod rejoined the session? I don't think so.
This is position 15, Gilmore from McLean.
Okay. 15. And what were we doing with Mr. Gilmore, Mr. McLean?
That's a not guilty, and I'm going to request a bond modification of the signature bond is request.
And did we get to the point of arraigning him or not?
No, we have not.
Good morning, Mr. Gilmore. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Please swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Gilmore, you have been charged in case 22 CR 007027F with simple battery. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do. We've read it, Your Honor.
Okay. How do you plead to this charge, Mr. Gilmore? Guilty or not guilty?
I didn't do it, but I just want to listen to my attorney.
Okay, so it's my understanding, Mr. Gilmore, that you are going to plead not guilty to this charge today. Is that correct?
Yes, sir.
Okay, we'll record your not guilty plea, and your case will be returned to the division judge, and you'll get notification of your next hearing date. Let's see, I gave Mr. Gilmore a $2,000 good bond on October 18th. And there was also an MHET requested at that time. Has that been completed?
Not that I'm aware of. No, he's in ongoing mental health treatment and with meds. At any rate, I can give a little bit of background on that.
Okay.
He went to Anchor Hospital for a time that ended about a month or so ago. And when he came out, he really wasn't quite stable enough to come out, but he was released anyway. Then this incident happened, and now he's been arrested on it a few weeks after the incident. It is one count of simple battery on his brother. It's a fairly simple fact pattern, and it's one where we think in the long run there's going to be a good resolution. In the meantime, Your Honor, I would mention that he is working full-time at FedEx. His supervisor has the job waiting on him. And there was a little tension, and I don't mean to criticize anyone at all in the family, of course, but really out of an abundance of caution, the family contacted the workplace, and the workplace is thinking that, or I've been told that the workplace was thinking that inpatient was about to be in the offing again. But now that he's stabilized, he will pursue a plan. And I'll be talking to a psychiatrist and getting this nailed down. He'll be pursuing a plan that involves outpatients so he can work his job. He has a good apartment. Living arrangements do need to change a bit because his father is elderly and in poor health. And so there's going to have to be an arrangement made where his father can find a place, perhaps with another family member. I'm not sure. That all needs to be done, but the apartment in question is the defendant's apartment. So he's able to pay for his apartment. He's stable in his housing. Now he's stable on his meds. He's stable at his job. And he would like to ask the court to now consider the stabilization is the change in circumstance. He'd like to ask the court to consider signature bond. He does have a car. He gets back and forth to work in, and he's fine.
Okay, you told me that that he has a place to stay. Where is he staying?
Yes, the incident location is actually the defendant's apartment. He pays the rent.
Okay, and his brother's is Sean Gilmore,
Is the victim.
right? And have you spoken with Mr. Gilmore?
I've not spoken with Sean.
Okay, but I take it that Mr. Sean Gilmore does not live with Mr. Eric Gilmore.
That is correct. On the day of the incident date, he was visiting. He was visiting his dad, which means, of course, he was visiting his brother at the same time.
Okay. Ms. Sorry?
Yes, Your Honor. We did not initially ask for a stay away, or we have not asked for a stay away in this case. We did speak with the victim's wife, and based on what she told us, we actually put in the conditions of no further violent contact with the victim. So the state is amenable to the defendant going back to his residence and no further violent contact with the victim. We are amenable to a signature bond in this case. We ask that it goes through pretrial, as this is the defendant's first arrest. And now hearing that he is stable on his meds, we will consent to that signature bond.
Okay.
That would be super.
All right, so it'll be a $2,000 SOB through pretrial, no further violent contact with Mr. Gilmore, and that he stay on prescribed medications.
And we have a form for signature bonds upstairs on the second floor. Would Your Honor like me to do that, or would Your Honor want to do that?
Form right here, you can press and write it if you want.
That's perfect.
Okay,
Okay.
all right.
Thank you.
Good luck to you, Mr. Gilmore.
Thank you so much for sharing my case today, sir.
He was saying thank you for his.
Oh, you're welcome, sir. Good luck to you.
Want you to have a great.
All right, so Ms. McLeod is back with us.
Yes, Your Honor.
Ms. McLeod, what are we gonna do with Mr., I believe it's add-on 3, Mr. Myers?
I spoke to my client, Your Honor. I was not certain as to the complete term of the plea offer that was on the table. It was my understanding that it was going to be a time served plea, but I was not sure.
It's my understanding, I've got down 12 months to serve, 36 days, credit for time served, 18 days, balance probated, a 6-week anger management course, and it's probably a stay away. Right, Mr. Tolan?
Yes, Your Honor. Go ahead.
Yes, I just received notification from my supervisor that it'll be 12 months to serve now, since it is being investigated as a hate crime.
Okay, well, in that case, I am going to grant his request for a signature bond. It's going to be the good bonds are going to be changed to signature bonds, $3,000 signature bond for the simple battery, $1,000 signature bond on both the disorderly conduct. They're going to go through the jail, no further contact with Michael Anderson, and stay away from all MARTA properties. So, Ms. McLeod, when you get to a place that you can draw that up, I'll be happy to sign it.
Thank you, Your Honor.
All right.
Congratulations.
Judge, you said it was through the jail?
Yes.
Thank you. We're completed here in courtroom 2, Judge.
All right. Thank you so much. We'll see you this afternoon, I guess.
All right, see you this afternoon.
Concluded, Judge, may I be excused?
Yes. Have a good afternoon.
Well, make sure you send information to Katrina Lewis.
I will.
Thank
Okay.
you.
All right. Who do we have next?
Position number 8, Warren North.
Position number 8, Mr. Chavez has a number of counts on the calendar that have already been reset until next week's calendar. So he's position
837 and an add-on,
837 and add on 1. So
different name.
Mr. Chavez Vasquez, I'll see you back next week.
And I'll be in touch with his mother.
Okay. And we still have a number of positions, I believe.
I gotta go to 3 get the other guys. Give me a moment.
Okay, thank you.
Thank you.
We'll be in recess until someone else comes back.
You need the positions and you're.
This is position number 24, Lewis.
I would have had a minute to speak to the attorney for a second this year. Ms. Ellen? I thought I was gonna see my mom.
And this is going to be an arraignment
And a bond hearing, Judge.
hearing, okay? Morning, Mr. Lewis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video? Can you hear me, Mr. Lewis?
Yes, sir.
We're doing this by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Lewis. You have been charged in case 20 CR 004413Y with simple battery and 2 counts of battery. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you wait for a reading of the accusation, Ms. Helen?
I do, Judge.
How do you plead, Mr. Lewis? Guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Do I have that? Do we have those bonds? Okay. Ms. Helen, do you know what the current bonds are?
$9,000 surety bond, Judge, $3,000 for each count.
That's correct, Judge.
Okay. What's the history, Ms. Harrison?
Yes, Judge, 8 cycles, last arrest. July of this year for aggravated battery, obstruction of law enforcement officers, criminal trespass. Case number 22CP210766. Additional open case 22SC184666 for aggravated assault, family violence, aggravated assault strangulation, family violence, 2 counts, terroristic threats, aggravated stalking and battery, family violence. Additional open case 22SC184813, aggravated assault strangulation, family violence, aggravated stalking, false imprisonment, terroristic threats, aggravated assault, family violence, battery, family violence. And a 2012 aggravated assault and robbery. We received first offenders and it was sealed 2020. Nothing further to add.
Ms. Helen?
Yes, Judge, this is a bond hearing today. Mr. Lewis is 42 years old. Currently, he's the father of 1 stepchild. He does have 3 others, Judge. He doesn't have any shared children with the alleged accuser, Judge, but he is a lifetime resident of Fulton County. He was born at Atlanta Medical Hospital. He currently is very employable, Judge. He works at the Roswell Car Spa as a detail technician, has been doing so for the last several years, Judge. His mom and dad are in Fulton County, specifically around the Campbellton Road area. I tried to contact his mom to be here today. She wasn't able to, Judge, but she wanted the court to know that she does support her son fully, even though she wasn't able to make it today, Judge. He has had some high school history, Judge, and is looking to get his GED once he's able to get out. Judge, I have heard the history. When I went down and spoke to Mr. Lewis, he is quite shocked at the other charges that have been added. He is not aware of any allegations, even in those cases. He was just made aware that those charges were just added recently, Judge. So today we are petitioning this judge, this court for a bond modification. Right now, it is a $9,000 surety bond for each. Judge, we are asking first for a modification to a surety bond of no more than $1,000 for the, hold on one second, $1,000 for the first battery, Judge, $1,000 for the second battery, and then for the simple battery, no more than $500 surety. I do hear the history, but again, Judge, those are allegations. I spoke to him. He is just becoming aware that those charges were just added, Judge. He plans to fight each and every one of these cases to the full extent, Judge. That is why we're having this bond hearing. I do not believe he's a danger to any of the alleged accusers. He does not have any contact. He does not want any contact, Judge. And so, Judge, we are asking for that bond modification, as mentioned, to no more than a $2,500 surety bond for Mr. Lewis.
Given the history, I'm going to let the bond remain as it's set. Good luck to you, sir. And I have that we still have 4 people that we need to see this morning.
Position number 21. Franklin
Okay.
Hughes.
And Judge, the only at issue here is the reason why it's non-negotiated is that Mr. Jean would like to use his NOLO, and we are petitioning the court and the state if they're amenable to allow him to use his NOLO plea in this case.
Any objection?
Which position is that, Judge? I'm sorry, I missed that one.
21, Mr. Jean.
No objection to that, Judge.
All right. Good morning, Mr. Jean. I'm Judge Eric Morrow. This is the state on purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Tole?
Yes, Judge, the state's bond recommendation is credit for time served, 24 days, balance suspended, stay away from the incident location, 1339 Andrew Street Northwest, Atlanta, Georgia, 30314.
Yes, Judge, that is our understanding of that plea. It is a time served deal. We just only asked Mr. Jean allowed to use his NOLO.
Okay. Mr. Jean, it's my understanding that in case 22 CR 003470E, you wish to plead NOLO to willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir. Understood.
Has anybody forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Mr. Jean, good luck to you, sir.
Thank you.
Thank
You're
you, Judge.
welcome.
Position number 18 and add on position number 1.
Okay.
Mr. Harden is pleading not guilty on both, Your Honor, and plans to have family members make the bond for him.
Good morning, Mr. Harden.
Good morning.
Good morning, sir. This is a state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video? We're doing this by video. Is that all right with you, Mr. Harden?
Yes, sir.
All right, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Harden. You have been charged in case 22 CR 007051F with cruelty to children in the 3rd degree, theft by taking, battery, family violence, and two additional cruelty to children in the 3rd degree charges. And in case 19 CR 009714F with public drunk and criminal trespass and damage to property. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation?
We do.
How do you plead to these charges, Mr. Harden? Guilty or not guilty? It's my understanding, Mr. Harden, that you were going to plead not guilty to these charges today. Is that correct?
Mine as well.
If I plead guilty, what consequence?
I'm happy to let you speak with your counsel regarding that. The state is offering additional jail time on these charges, so you may not be able to get out today. If you want, Mr. McLean, if you need for me to reset this to another time so you can speak with him regarding it, I mean.
Your Honor, a 1 week reset would be okay. We had quite a long discussion with.
Yeah, I pleaded guilty.
Excuse
If
me.
I plead guilty, we discussed that yesterday. I got a sick brother at home. I need to get home.
Right, we discussed and we went back and forth so many times. He fully understands both pleas. He just,
Yeah, I pleaded guilty.
like, couldn't quite make up his mind.
Okay, so I'm going to reset you 1 week so that you can speak with Mr. McLean again regarding this, Mr. Harden, okay?
Okay.
All right, so I'm going to see you back here next Tuesday, 11/8.
Okay.
All right, I'll see you next week, sir.
Okay. Thank you.
You're welcome.
Thank you.
Judge, you say you had one other person that was missing?
We have two other people, position number 9 and position number 20. Position 9 is Travis Clark.
Oh, Mr. Clark was unavailable for interview, and that's been the case for some weeks.
Okay, and position number 20 is Alan Jacobs.
That's a negotiated plea.
Okay, so we need Mr. Jacobs. All right, so what do you want to do with Mr. Clark?
I'm
Reset
beginning to
him.
despair of the idea of ever laying eyes on him. I've talked to my supervisor about the idea of talking to the watch commander about going to what's called the horseshoe. It's an area in the cell area where we can get closer to him and he won't have to come up to the visitation booth.
All right, so you want me to reset him for next week?
Yes, Your Honor, that'd be great.
All right, so we still have to do Mr. Jacobs and Ms. Lewis, can we go over the calendar while we wait for him?
Can everybody hear me? About to go over the calendar. Hello.
All right, are you all ready to go over the calendar? If you, Ms. Sorry, it's the only one that I have on video, Mr. McLean also, so just want to make sure that you all are with us. Okay.
All right.
Okay. Position number 1, I'm doing the add-on counter first. Position number 1 on the add-on counter is set for SAP November the 8th. Position number 2 on the add-on counter is set for SAP November the 8th. Position number 3 on the add-on counter should be set for the notice defendant was arraigned, not guilty, and the bond was modified. To the regular counter. Position number 1, defendant was arraigned, not guilty, cases be set for trial for the notice. Position number 2 was a plea. Position number 3, defendant was arraigned, not guilty, case be set for trial for the notice. Position number 4, 5, and 6 was a plea. Position number 7 was a plea. Position number 8 is set for SAP November the 8th. Position number 9 is set for SAP November the 8th. Position number 10 is going to be set for the competency counter for November the 17th. Position number 11, defendant was arraigned, not guilty, cases we set for trial for the notice. Position number 12 was a plea. Position number 13 was a plea. Position number 14, defendant was released, case was set for the notice. Position number 15, defendant was arraigned, case was set for trial for the notice. Bond was modified to $2,000 signature bond. Position number 16 was a plea. Position number 17, defendant was released, case was set for the notice. Position number 18, we set for SAP November the 8th. Position number 19, defendant was released, case was set further notice. Position number 20, we're holding. Position 21 was a no low plea. Position number 22, defendant was arraigned, not guilty, case is set for trial for the notice. Position 23 is set for SAP November 15th. Position 24, defendant was arraigned, case is set for trial for the notice. Position number 25 was a plea. Position 26 was a plea. Position 27 was a plea. Position 28 is set for SAP November 8th. Position 29 and 30 was a plea. Position number 31, defendant was arraigned not guilty, case is set for trial for the notice. Position 32 was a no-go plea. Position 33 was a plea. Position 34 is set for SAP November the 8th. Position 35 is set for SAP November the 8th. Position 36 was a plea. Position 37 is set for SAP November the 8th. Position 38, defendant was arraigned, set for trial for the notice. And we're gonna get his probation case on the next verification calendar. Position 39, defendant, case is set for SAP November the 8th. And position number 40 was a plea. Any questions from the side? Thank you. Please make sure you send all the plea paperwork to the town. Yes. We'll find it there. Thank you.
All right, holding on position 20, Mr. Jacobs. Yes. Ms. Champion, are you there?
Yes, sir.
I'm not sure if they knew that if they know that we need Mr. Jacobs. Their camera doesn't appear to still be active. Could you just follow up, make sure that they know we need position 20, Mr. Jacobs, for me?
Yeah. Yes, I'll contact the courtroom.
Thank you.
Sorry to hear that.
Okay, position 20 is going to be a medical reset. I guess we'll reset it for next Tuesday, 11/8. Okay, I believe that completes the 9 o'clock calendar. Thank you all. I will see you next Tuesday.
Thank you, Judge.
Thank you, Judge.
Have a good rest of your day.
You too.
Yeah, I'm gonna run upstairs and get those plea forms.